We are now done with all of the evidence in the jury trial of the 3 men charged with killing Ahmaud Arbery, and in this video, I'm going to recap the 3rd week of jury trial. Coming up. Hello, my name is Clyde Guilamo, and I am a lawyer in the Chicagoland area, and in Law Talk for Non-Lawyers, we talk about the law in plain English. Viewer discretion is advised, as in this video, I will be talking about a homicide case, the killing of Ahmaud Arbery. I've divided this video into 3 parts. First, let's talk about the evidence as it appeared on the last week of the jury trial. Then let's talk about some of the motions that have been argued before the court. And lastly, let's talk about the outcome of the Kyle Rittenhouse trial and how that should impact the lawyers in going into their closing arguments. Alright, starting with a summary of the facts as they came out in the last week of trial. So we have the state finishing their case in chief. They put on all the witnesses that they planned on using to go ahead and prove these 3 individuals guilty of killing Ahmaud Arbery. And one of those key witnesses that they brought in this last week of jury trial was the medical examiner. He was the one who did the autopsy on Ahmaud Arbery. He talked about how he died from a shotgun wound, and I do have a clip to play for you. So here it is, the medical examiner who examined Ahmaud Arbery's body.
Did you then formulate an opinion on the sequence of shots?
I did.
All right, tell us what that opinion was.
Well, it was my opinion that the shot to the center of the chest and the grazing gunshot wound to the wrist occurred at the same time, meaning that the hand was in front of the chest and was struck first, and then it entered the body. It was my opinion that the second shot was a complete miss and did not enter any part of the body, and that the third shot involved the left chest and axilla.
You testified that there was nothing that could be done on scene that could save Mr. Arbery's life. Is that correct?
I think that's correct, yes.
The phrase you used when you talked to us in March is, he was essentially dead before he hit the ground.
Yes.
All right, as you can see, it's very powerful testimony. It was testimony that was necessary for the state to present to the jury so that there's no doubt in the jury's mind as to what happened in this case, okay? Ahmaud Arbery died from a shotgun wound that was in fact inflicted by one of these 3 individuals, okay? Now let's talk about the defense's case in chief, okay? Because in a move that was interesting, they decided to put their client on as a witness, and specifically I'm talking about Travis McMichael. Travis McMichael is the person who had the shotgun, who fired the shotgun, who ultimately took Ahmaud Arbery's life. And here's some clips of his testimony to the jury that came up in trial.
On you doing what? He grabs the shotgun, and I believe I was struck on that first instance that we made contact.
What were you thinking at that moment?
I was thinking of my son. It sounds weird, but that was the first the first thing that hit me.
What did you do?
I shot.
Why?
He had my gun. He struck me. It was obvious that he was. It was obvious that he was attacking me. That if he would have got the shotgun from me, then it was this is a life or death situation, and I'm going to have to stop him from doing this. So I shot.
Did he stop when you shot?
He did not.
All right, so that's some powerful testimony, some emotional testimony, and ultimately it's going to go to the jury. But I'm going to ask you first, what do you think? Do you think that they are going to find all 3 defendants guilty or not guilty? Or do you think that they may find some of the defendants guilty and other defendants not guilty? If you can go ahead and comment below. All right, so let's move on to the second issue in this case, and that's motions. And specifically, attorney Kevin Go, he's the one who represents William Bryan. He filed a new motion trying to exclude now Reverend Jesse Jackson from the courtroom. Now, here's a clip where he's explaining his argument.
This time we would ask that the Honorable Reverend Jesse Jackson, who I believe is still here, of course, He is, Your Honor, I think we all know, an icon in the civil rights movement. He, not just a witness to it, he the personification of it. And in other circumstances, I think everybody would be happy to have their picture taken, maybe get an autograph. But in the context of this trial, we object to his presence in the public gallery inside the courtroom. We note that there is a jury assembly room capable of holding, depending on how we socially distance, several hundred people. How many pastors does the Arbery family have? We had the Reverend Al Sharpton here earlier, last week, but I don't know who Mr. Jackson, Reverend Jackson, is pastoring here. They also have attorneys. Mr. Arbery, Marcus, has a team of lawyers to comfort him through these proceedings. Certainly, Ms. Cooper has been amply comforted by her legal counsel. And we are concerned about whether it's conscious or unconscious, the impact of their presence with respect to the jury and with respect to the proceedings in this case. And I guess the next question is, which pastor is next?
All right, now look, there are certain parts of this motion which are completely improper. Commenting on the individuals who are there to comfort the mother who has lost a child, completely improper, and should not have been addressed. However, I don't want you to feel that there is no legal value or no legal reason for why he's filing this motion, okay? This motion is actually a proper motion, and here, let me explain, all right? The role of the jury is to decide the facts and ultimately determine if the defendants are guilty or not guilty. That is the role of the jury in this case, okay? And they are going to do that role by reviewing the evidence in the case, who comes in to testify. And you can challenge that evidence by cross-examining those individuals, asking them questions to really figure out if it's true or not true what someone is ultimately saying. That's one of the things that we have as a right in the criminal justice procedure. We have the right of cross-examination, putting the evidence to the test, okay? Now, because this is the role of the jury, his concern is things that could influence the jury that are not coming from the witness stand, that are not coming from the videos that are being shown to the jury, like influential people appearing in the case. Last week it was Al Sharpton, this week it's Jesse Jackson, and his concern is that these individuals are coming because they're interested in the outcome of the case. And because it is the jury who is going to determine the outcome of the case, their interest in appearing could be seen by some individuals as influential, as I should go ahead and decide this case in one way or the other because someone who is influential has made their presence be known, that they're interested in the outcome of the case, okay? And that is not going to be cross-examined by the defendant. The fact that there's someone present in the gallery who may possibly have an influence on a prospective juror or not, okay? So the argument is that these individuals who are influential may in fact influence the outcome of the case. Now, on the other hand, the competing interest to the one that's being expressed by the lawyer is the fact that the Constitution allows for public trials. This is the 6th Amendment of the Constitution that has the right to public trials. It means that members from our community, if they so choose, can sit in and see how our criminal justice process works. This is what it means to be American. We bring in public juries and we have public trials, okay? And ultimately what the judge is deciding is this: he will continue to keep a public trial and allow members of the public in to be able to see the criminal justice procedure in action, as long as these individuals are not interfering with the trial in this case, okay? So let me ask you, what would you have done if you were the judge? Would you in fact exclude influential people, celebrities from the trial because they could possibly influence the jury? Or would you have still allowed these individuals to sit in as long as they were able to abide by the rules of the court, remaining silent, not making a commotion, etc.? What would you have decided in this case? All right, now let's talk about the outcome of the Kyle Rittenhouse case and how that might impact the lawyers as they prepare for their closing arguments for tomorrow. Okay, starting with the Kyle Rittenhouse case. That was a case in which an individual went to protect the private property of another. And if we look at the case with the McMichaels and Brian, we have these three individuals going out and protecting the private property of another. Okay, in both cases, we're dealing with private citizens ultimately engaging in something that is often left for law enforcement, okay, which is the protection of private property, okay. Once again, in both cases, the individuals who went out to protect private property decided to become armed prior to going out. In Kyle Rittenhouse, he had an assault rifle. In the case of the McMichaels and Brian, the McMichaels were armed with both a shotgun as well as a handgun, okay? In both situations, the victim, the deceased, they closed the distance between themselves and the defendant in the case, okay? In Kyle Rittenhouse case, there was a video that captured the victim lunging towards Kyle, and in this case we have a video showing Ahmaud Arbery closing the distance with Travis McMichael, okay? And ultimately in both cases the defendants claimed self-defense. Kyle Rittenhouse said that he shot these individuals because of self-defense, and of course Travis McMichael is saying that he shot these individuals as a result of self-defense, okay? So there are a lot of similarities between these two cases. However, there are differences, and we're gonna see if maybe these differences ultimately result in a different outcome of the case. And the one major difference is this, is that in Kyle Rittenhouse's case, he was actively retreating from the victim in that case when he ultimately fired his gun and shot the individual, okay? He was actively retreating. In the case of the McMichaels and Brian, they were actively trying to confine or stop or detain the victim at the time that the shooting occurred, okay? So this is going to be the question of whether or not self-defense applies. Are you the initial aggressor? In the Kyle Rittenhouse case, the answer was no. That question still has not been determined in the Ahmaud Arbery case, okay? So what should the defense be on the lookout for in this case? Well, what you can learn from the Kyle Rittenhouse case is that the Second Amendment is still alive. You still have individuals who are part of your jury who believe in the right to bear arms, okay? And you have individuals who believe in the right to use those arms in self-defense, okay? So the defense is really gonna wanna limit the time here. They're gonna wanna have the entire case be of the few seconds in front of the car of the McMichaels when Ahmaud Arbery closes the distance with Travis McMichael. If they can really focus on that issue, that is going to be what a compelling closing argument is going to be, okay? Now, with regard to the state, they're going to want to stay away from any comments on anything about constraining someone's Second Amendment right or self-defense, okay? They want to reframe this case. This case is going to be about three individuals taking the law into their own hands and trying to trap Ahmaud Arbery, okay? They want to lengthen the time and lengthen the scope. Don't just look at the seconds in front of the McMichaels car. They want you to look at the fact that on three separate occasions, they boxed this individual in, and finally, on the last occasion, they were getting out of their vehicles with firearms, okay? It's really going to be a question of the scope. How big or how small can they make the scope, okay? Now, once again, to you guys, what do you think? How is the jury going to interpret these issues, and are they going to take the larger scope that the prosecution is going to want to give, or will they take the smaller scope that the defense is going to want to give? We don't know, but we're going to find out as this case is going to the jury tomorrow. All right, guys, take care. Bye-bye.